Thank you for being with us this morning in Namibia Connects.
Thank you for inviting me.
Professor, there are roughly 75 proposed changes currently on the table for the 2025 Labour Amendment Bill. In your expert view, how do these amendments fundamentally shift the landscape of Namibian labour relations compared to the existing 2007 Act?
Well, thank you very much for the question. The change is fundamental. It's not simply a tinkering of the law. If you look, for example, at the evolution of this process, I mean, it has been 10 years. It started in 2015 and is ongoing. You can see that we have actually shifted from consolidating the law to actually being more proactive. It's a fundamental shift where now the lawmaker and the social dialogue, the government, employers and trade unions, they are now trying to entrench existing rights. It's a more proactive approach, and it is a fundamental shift.
Proposal 4 aims to explicitly include the informal economy under the protection of the Labour Act. Given the unique challenges of this sector in Namibia, what are the legal and practical implications for millions of workers who previously had no formal recourse for labour disputes?
It is one of those aspects of the new bill that makes this legislation fundamental. Section 3.2 of the draft Labour Amendment Bill includes the informal sector within the scope of the Labour Law, of the Labour Act. So that would mean that street vendors, domestic workers and gig workers, including, for example, Yango drivers, will fall on the, traditional taxis will fall on the scope of the Labour Act. And it's also important considering the fact that the informal economy employs roughly 58% of the workforce. So that is the majority of workers. So it is, as I said, one of the highlights of this new draft bill. Yes.
The bill introduces a comprehensive new section on the prohibition of violence and harassment, aligning with ILO Convention 190. What specific new duties does this place on Namibian employers to investigate and remedy psychological harm? And how does it redefine the concept of a hostile work environment?
Yes, one of the things that has been added to the Labour Act, because in the past, on the Section 6, if I'm not mistaken, it was already dealing with sexual harassment and discrimination. The difference now is that they have Section 1 of the draft bill defines violence and harassment within the context of the world of work. And it is defined broadly to even include psychological harm. And this provision, we're talking about now Section 7 of the draft bill, creates an obligation on employers when they receive reports of violence and harassment. It creates a duty to investigate and remedy. So this is the key phrase, to investigate and remedy instances of violence and harassment. Yes.
Now, a significant point of contention remains parked regarding a definition of managerial employees. Why is this definition so critical for trade unions? And how could a broad interpretation potentially strip thousands of Namibian workers of their rights to unionize and receive overtime pay?
Yes, I was fortunate to facilitate dialogues during this process from the dialogues that trade unions and the trade federations had on this issue. The concern of trade unions with the definition of managerial employees, that it could be abused. So the proposed definition in the draft bill, which is, in the draft documents, because there's not been included in the bill yet, because it's, as you correctly said, it remained parked. Parked is a term that you'll find in the documents, for example, that the tripartite task force is a task force that included a representative of the government, employers and trade unions. In that document, they use the term parked to say that the social partners have not yet reached an agreement on this. So in those documents, the definition of managerial employee, it's an employee who represents, who has the authority to represent the employer internally and externally, and who also participate in the formulation of the employer's policies. Now, the employers are suggesting that, task force suggests that, as proposed that definition, but trade unions that see that it can be abused in the sense that an employee can be designated as a manager, so that that employee will not be able to benefit from overtime pay, and also will not be able to be represented by trade unions. So this is the reason why it is parked up to date. In my humble opinion, I believe that if the definition could include compensation, in the sense that if we can, who counts as manager should be determined in terms of how much they earn relative to other employees. So, for example, if the average pay is 50,000, and you see that an employee earns, for example, 75,000, it would make sense for that person to be classified as a manager and to be, let's say, excluded from overtime pay and also trade union representation. But if a person earns a relatively lower salary, it wouldn't make sense. In that case, it could become abusive. So in my own expert opinion, I believe that one way of reconciling the position between employers and trade unions in this case would be to try to come up with the pay-based or compensation-based formula to determine when an employee could be lawfully classified as a manager.
The bill proposes increasing the minimum working age from 14 to 16 years to align with the Namibian Education Act. Beyond the Act change, how do the new powers granted to labor inspectors to remove children and lay criminal charges strengthen our national fight against child exploitation?
It does strengthen, and it does also advance the provisions of Article 15 of the Namibian Constitution. One of the reasons why this was proposed was to align our labor law with the Education Act 16 of 2001. Because if you look, for example, there are several provisions, but if you look, for example, at Section 53, you will see that they are talking about 16 years of age as being the age where there is a compulsory or mandatory, attendance of of schools. So this is a recognition also that our children belong to classrooms and not to workstations. So it's to align with the law, but also to advance the goals of Article 15 of the Namibian Constitution. Section 4.4 of the draft bill has also empowered labor inspectors to remove children from hazardous sites. So if, for example, they believe that at a certain workplace, at a certain site, children are at risk of injury or they are exposed to health risk, then labor inspectors are empowered in terms of Section 4.4 of the draft bill to remove children from such workplaces.
Do you think that we are doing enough in terms of children being exploited? Like there was a story on the news where children were detained. Do you think the law is doing enough, or bringing an awareness to the public and how serious this crime is?
It is definitely serious. If you look, as I said, at Article 15, you look at the court decisions, and you also look now even at the willingness of the social partners in this case to make sure that children are protected. It is very clear that it's a public policy. Those are values that actually protect children from that kind of exploitation. Now, are we doing enough? Because that's the question that you have asked. I believe that from even my engagement throughout this process with the trade unions, that one of the shortcomings is the fact that there aren't enough labor inspectors, because Section 4.4 says that labor inspectors can now remove children from hazardous situations, but how many labor inspectors are there? You can make these provisions, but if there aren't enough labor inspectors, you'll find situations, unfortunately, coming up, situations arising where we find out that some children are being detained, which is illegal, or exploited in other ways.
I think the idea of detaining them is so that the parents can come, so that they can question, why are your children on the streets?
Oh,
I think that was the idea.
Okay, no, I actually got it the other way. I thought that employers were detaining children.
No,
I was wondering.
I think the law enforcement just kept them so that the parents can come because they wanted to know, why are you sending these children to sell things on your behalf? And I remember one of the parents was saying, look, the situation is really bad at home. So he has to sell. I need to also sell. But some of the parents were apologizing. It was one of the stories we had.
Oh, okay. Well, in cases like this, it will depend, first of all, on the empirical data that we have so that we have a clear idea of what is the situation right now. I believe, as I said, that having enough labor inspectors would be important, especially in terms of removing them from dangerous workplaces in terms of health and safety. But even from the scenario which has happened that you just described, it will be important to also involve social workers. So it's not just from a labor perspective. There will also be you will need to have the involvement of social workers. The constitutional framework is there, as I've already mentioned several times, Article 15. But whether in practice it can actually work, first of all, we will need to have the data that will inform the policy and how it's being implemented. But as I said, just by looking at the labor inspectors' side, we have the impression really that there aren't enough inspectors.
Professor, in terms of the future, what do you see concerning the bill?
Well, it is as I said, a radical shift when you look at just even the numbers. 75 proposed changes, although there were about 4 parked issues. If enacted by Parliament, this is likely to radically or fundamentally change labor law and labor policy. To just give you an example, there is a definition of workplace that includes digital workplace. So that is important considering now the world in which we live with the artificial intelligence and so forth. The importance going forward, and I want to highlight this now, is that it will be important that on the parked issues, whether it's the unilateral alteration of the terms of employment or the managerial employees that we've just spoken about, it will be important that they find consensus. The discussions, from what I've observed, also have already reached a very advanced stage, but it will be important to have to resolve those parked issues, because if they are not resolved, then the draft bill, the latest draft is the 3rd of June, was passed, adopted on the 3rd of July 2025 this year, but it has not yet been enacted. So if they do not find consensus on those remaining parked issues, it's going to go through a stormy passage in Parliament, and it's not very likely. It may be delayed. It may take longer if there's no consensus on this. Consultation and consensus in this case is the price of industrial peace. If that consensus is not found, then we should expect more litigation, more disputes down the road.
Any final remarks? Anything that you'd like to add?
Well, I mean, on a personal perspective, it was quite enlightening to engage with those issues through the Labor Resource and Research Institute. And I facilitated discussions with the trade unions, the confederations, and I would like also to underscore the special significance of this exercise, not only because of the substance of what is contained in the Act, but also the fact that the 3 confederations, the 3 federations, labor federations of Namibia, TUCNA, NUNW, and NANLO, came together. It is, it's quite right, it's unprecedented, but it signals the importance of this exercise, also considering the data that we have received that show that unemployment levels are quite extraordinary, especially for the youth. So this is a question and a process that everyone should embrace and share their views, because the process is ongoing. So if there are flaws, or if on the parked issues they have suggestions as to how it can be resolved, then this is the time to do it.
Professor, thank you so much for taking time and being with us here.
Well, thank you very much for inviting me.